Breaking tonight, Chad, a judge sharply challenged an NFL player's explanation in court, immediately shutting down what were described as weak excuses. Now, let's review the key evidence, courtroom developments, and official findings that shaped this case.
Welcome back to the channel. Today we're spending a day in Judge Stephanie Boyd's San Antonio courtroom, and trust me, this one's different. We've got a superfan who flew in from Wisconsin, a jail bus that broke down, and a judge who confesses her Mac rib addiction on the record. But beyond the lighthearted moments, we're diving into cases that'll make you think, what do we do when cancer patients steal? When NFL players make threats? When abuse victims become defendants? Let's get into it.
Judge, there is a gentleman here from Wisconsin.
Sorry?
There's a gentleman here from Wisconsin. He's seen 400 of your episodes, and he wanted to personally meet you. He told the bailiff, and he came in, he's here visiting.
Where is he?
Mr. Cook? Mr. Cook, could you stand up, please?
Hi, Mr. Cook. Are you Mr. Cook?
Yes.
Hi, Mr. Cook. I'll come out and meet you in a little bit, okay? After I call the docket.
Thank you.
All right. Welcome from Wisconsin.
Thank you.
Yes.
You're a celebrity now, Judge.
No, I'm just doing my job.
He says he likes your temperament.
Nice. All right. So everyone, please pay close attention. 1, the van or bus, whatever you want to call it, that brings inmates over, needs to be looked at by a mechanic, or is a new one needed? Do we need to take up a collection to get a new bus? So it's broken down. Now, what does that mean? That means you're going to have some extra patience in your pocket. Don't get upset with the deputies if your inmate is not here because the bus is broken down. So they can only bring 10 people over from the jail at a time. Now, why didn't the city design downtown where the jail is next to the courthouses? We may never know. If somebody wants to do some research, we have some interns here. If y'all want to do research on that, you can, to find out why that happened. So you need to be patient. And remember, this is Christmas season. So Santa knows when you're sleeping. He knows when you've been good or bad. So be good for goodness sake. So let's not get upset with the deputies because they only have what they have. And if you have a client who's admin seg, they have to bring them up separate from everyone else. So everyone, please be patient. At 9 o'clock, I am going to call the docket. And Rick, last night I had zero help. Megan, you're to blame.
I love how Judge Boyd handles the chaos, broken buses, superfans, Mac rib confessions with this calm professionalism. But what really struck me was what came next. A defense attorney is trying to retire, overwhelmed by the job, and Judge Boyd doesn't just move on. She stops everything to give him advice that every lawyer, every person needs to hear.
She's in the wind. I have communication with her, trying to get her to turn herself in. She doesn't want to do it. The only concern I have is we're on today's bond. I know she's not here. She already has a warrant on the case, so I'm asking the court if the court could do an increase or a judge's warrant.
No, I've already done a judge's warrant on the violation. Yes.
Okay, that's what I thought.
Yes.
But I just wanted to make sure everything was.
No. There's a judge's warrant that was issued on the pre-trial violation report.
Did the bond double or?
No, there shouldn't
Oh,
be any bond. Yes.
Okay.
Because normally when I do, the rules are when I do a judge's warrant, the bond, if somebody wants a bond, it comes back to me.
Okay. That's fine. Once she gets picked up, she will have to remain in. They will not be able to afford the situation. So that's the update.
All right, thank you.
And have a good Christmas.
Well, you too.
New Year.
Oh, happy Festivus.
Festivus
Happy
for
Kwanzaa.
the rest of it.
Yes, happy Kwanzaa.
Not make it to Paris after all.
I will.
My wife claimed work dates. She didn't have the days.
You know what? It's like work is always going to be there. You know what was it? Cornelius Cox told me, and Grantley Box Hill. You remember Grantley Box Hill? Everybody called him Box. He was an investigator. Had a beautiful Caribbean accent. Well, this is what they told me.
Count, remember the count?
Yes.
Thought about that guy the other day. I don't know why.
So as defense attorneys, you work. I wouldn't take time off. I would work. And they would tell me, Stephanie, even if it's a staycation, you gotta take some time off. And so I said, yeah, but I can't. They said, if you were to die tomorrow, you know what would happen? And I'm thinking, oh, are people going to be crying in the streets, saying she was too precious for this world? They said, we will be sad that you're gone. But what's going to end up happening, people are going to take your cases. They're going to say, hey, we need more different attorney on all these cases. So that made me pause to remember to take care of self, sometimes you have to do self-help. And I don't think people realize how hard defense attorneys' jobs are, because you truly are the attorney, the counselor, not just the counsel of law, marriage counselor, therapist. You have to do all of that. Then find your client. Then you have to be your client's secretary and manager, reminding them of the court dates.
Wear a lot of hats.
Oh, yeah, you do. So work will always be here.
I know. You're preaching to the choir on that here. Anyway, y'all have a good holiday, Bill.
You too.
See you in the
And
evening.
happy Hanukkah.
Yes,
And then
ma'am.
happy holidays covers everything.
Work will always be here. That hit hard. The legal system burns people out, defense attorneys, prosecutors, judges. We glorify the grind, but Judge Boyd's saying, take care of yourself because no one else will. Now let's talk about a case that tests that balance between compassion and justice. Walter Prince has leukemia. He's being treated at a hospital, and he keeps stealing from that same hospital.
Court is calling 2025 CR 006467, State versus Walter Prince. Could I have parties announced for the record for the state? For the defense?
Joseph Appelt.
And you're Mr. Prince? All right, Mr. Prince, you entered a plea bargain agreement with the state to count one of the enhancement was found to be true. My understanding is that the plea bargain agreement, the state is to remain silent on your application, and punishment is to be assessed at a cap of 7 years. And there's to be no contact with UT Health Science Center except for medical treatment. All right, Mr. Prince. It appears you have a problem with stealing. So why, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record. All right, why do you steal? Why are you stealing? Well, I mean, you do know, because it takes some thought to do it. And let me just tell you, the only reason why the state is silent, the only reason why you're going to receive probation for this from this court is because of your medical issues. And I know that the jail and the prison system, they're not 100% equipped to provide you treatment you need for your leukemia. Otherwise, you should be going to prison. And obviously, maybe there's something mentally going on with you. Usually I know when people are going through treatment, sometimes they need therapists for mental health, because sometimes treatment is a roller coaster. You're doing great, you're not doing great. So I understand that. And your attorney has brought to the state's attention and to the court's attention the fact that it is true that that's your diagnosis, that you have been receiving treatment. And that is why you've been at the Health Science Center. So this is what I'm going to tell you. I'm going to grant your application. However, I will only grant your application if you're applying for deferred adjudication. And I do have your application for deferred adjudication. And I'm going to place you on deferred adjudication. And you know why I'm doing that? Because if for some reason you were revoked, you're subject to the full range of punishment, and that's up to 20 years in the prison. So you had better not steal anymore. You understand? If you want things, you need to work for things, and you can not use the fact that you have medical issues as an excuse to steal. All right, this is what the court is going to do. The court is going to sentence you to 6 years deferred adjudication. The mouse is slow.
One factor and component that I think the court needs to be aware of as well, in his medical records, it does indicate that he has been diagnosed with partial idiopathic epilepsy with seizures.
Okay.
So that'd be a physical thing, not a mental issue. However, I'm not sure how that would be addressed other than through medical procedures and medical medication.
Okay. All right, there's going to be 6 years deferred adjudication, regular reporting by Zoom or in person, regular random UAs. Are you employed? So how do you support yourself?
I'm getting assistance from my family.
Okay, I cannot hear you. You're gonna have to speak up.
Sorry.
That's okay.
I'm getting assistance from my family.
Okay. And do you live with someone or you live by yourself?
By myself.
All right. Do you have any children?
They're grown.
All right, there's gonna be proof of employment within 45 days or proof of SSI within 45 days. Or you can provide medical documentation that he's unable to work, and that needs to be done within 45 days. If not, he'll obtain employment, and he's not allowed to have any employment as a home health care provider or with minors. There's a $1,500 fine that will be probated. There's to be no contact with the Health Science Center except for treatment. Restitution, if any, to Melinda Stelp, STELPFLUG. There's going to be 100 hours of community service restitution. I'm going to require the anti-theft course. And Ms. Abrams, when is his MIC evaluation scheduled? All right. And he's to attend the MIC evaluation. If you miss that evaluation, a motion to revoke is going to be filed. You understand? All right. Field visits 1 time per month for 8 months. Probation. Is there anything else?
No, sir.
Do y'all need him to do a medical release?
Judge, his officer will go over that with Judge.
All right, so you'll need to provide any type of medical information. If your doctor says you aren't able to work, you'll need to provide that to probation, and you need to do that within 45 days. Do you understand?
Yes.
All right, is there anything else you need from the court? Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
All right. You had better follow through on everything. Otherwise, it's not going to go well. You understand?
That was brutal to watch. 6 years deferred adjudication for a cancer patient who's stealing to survive, or is he? Judge Boyd clearly struggled with this. She's giving him a chance, but with a warning: you're subject to the full range of punishment up to 20 years. Now we're jumping to a very different case. Former NFL player, custody dispute, and intimate photos used as weapons.
It's going to have to come in to swear your client in.
Okay, Judge, just to let you know, they sent me some paperwork. I'm not sure why they sent it to me, but I just forwarded it to Norma.
All right, thank you. She's received it.
Okay, thank you.
Judge, I'm gonna print it in the back.
All right. Jonathan Carter. All right, the court is calling 2025 CR 007350 State versus Jonathan Carter. Could I have parties announced for the record?
Jeffrey Wright for the state.
Caitlin Knowles for Mr. Carter.
All right, and excuse me, the other attorney, if you can come forward. And also for Mr. Carter, if you could state your name, please.
Kyle Simpson.
All right, have both parties, I'm sorry, defense counsels, have you received discovery from the state and did you review it with your client?
We
Yes,
have,
ma'am.
Your Honor, and we did.
All right, court will find that state is in compliance with discovery. Mr. Carter, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Counsels, do you waive the reading of the indictment?
We do.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? You're charged with the offense of publishing or threatening to publish intimate visual material as a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? All right, why is everybody whispering today? All right, that's okay. It's like people are whispering for some reason. I can't hear. Court reporters having a hard time hearing. Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
All right. Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, ma'am.
Counsels, has your client been able to provide you with any defenses?
Yes, Your Honor.
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Yes, Your Honor.
Mr. Carter, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's a $2,000 fine and the state recommends deferred adjudication. Did you understand that to be your plea?
Yes, ma'am.
Defense is at the plea?
It is.
State is at the plea?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it?
Yes.
Just for a moment. Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
None.
Outside the
No.
agreement, thank you. Outside the agreement, the state is recommending that your deferred adjudication be for a term of 2 years. There be 100 hours community service restitution, TAP evaluation. The state has put zero tolerance. I don't do zero tolerance. You know, either you violate your probation or you didn't, and then I make decisions on that. a mental health evaluation, parenting classes, anger management class, BIP class, no harmful or injurious contact with the complainant. Did you understand that to be your plea?
Yes, ma'am.
Defense, is that the plea? Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
Yes, Judge.
I'm sorry, not the plea. Did you understand that those recommendations are recommendations from the state and the court does not have to follow those recommendations? And those are the recommendations that the court previously read which is the state is recommending 2 years. So I don't have to give you 2 years. I can give you more than 2 years. 100 hours of community service restitution. I can give you more than that. The mental health evaluation, parenting classes, anger management class, BIP class, and the no harmful or injurious contact. You understand that?
Yes, ma'am.
Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest? State any evidence.
State offers State Exhibit 1 and attachments. Without objection.
All right. And
No
state,
objection.
thank you. And state, have you spoken with the complainant?
Yes, Judge, and she's here today.
All right. Mr. Carter, did you review the waiver and stipulations of testimony with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, ma'am.
Yes, Your Honor, we'll waive PSI.
All right, anything you wish to say on behalf of your client?
Yes, Your Honor. So this, the offense as charged, right? Whenever you see that offense on paper, you know, it gives a certain impression. Our client was in the throes of custody issues. He understands that he made the wrong decision to take his anger out in that way, rather than, you know, addressing it in a healthy manner. Mr. Carter volunteers as a football coach at a local high school. He is a former NFL player, and he is giving his talents and giving back to the community in that way. He is fully committed to continuing that path. He is fully committed to working on himself, and this incident does not define him. He is remorseful, and he's ready to change under your supervision.
All right, why is there a request for BIPP? I'm sorry, you're not the attorney on this, but I mean, I understand that this is seen as a form of abuse, but isn't BIPP for physical battery?
Yes, Judge, and I can just imagine, because it's someone who was a spouse of his, and someone, this is not just some random person, and so
I mean, I'm not gonna order that. How old are you?
46.
All right, why are you threatening to send out videos?
I made a mistake.
No, you didn't make a mistake. You made a choice.
I made a choice. I made a bad choice. And didn't think why.
Like why? And why were you knocking on her door or knocking on her window? What were you expecting?
Talk on my daughter, but it didn't help at all.
Well, what time did you go to talk about your daughter? What time was it?
Late.
What does late mean?
Past a bedtime, 10 o'clock, I think. Well,
All right, nobody's knocking on somebody's door at 10 p.m. to talk about their daughter or talk about their child. They're usually there for something else. Did you call her? And I see you called her and she blocked you.
yes, ma'am.
All right, so it appears that she doesn't want you anymore. I don't know why people can't accept that. And it's not like you're a teenager. Even teenagers, when somebody doesn't want you anymore, you can move on. As my grandmother would say, cry on the inside. Don't let that person know they've broken your heart and just move on. I don't understand why you don't understand that.
If I may, I think context matters here.
Oh, yeah.
My understanding is that the complaining witness was withholding visitation from my client. And he had no way to do it. A custody suit has ensued and they're working that out. But during that time, they were breaking up.
So why would he go over her house after 10? Why not go over there at lunchtime? Why not go over there during, daylight time?
I think he was frantic, Your Honor. And he understands,
Why
right?
not? I want to find out if he was frantic. He hasn't told me anything.
I think we had the wrong way.
No, but I mean, why go to her place at 10? And the reason why I'm asking you these questions, it's so I can determine whether or not all of these extra conditions that the state is asking, whether or not that's appropriate.
Because at the time I was allowed to come over there, and the time I was so serious, and I thought to go over there.
What do you mean you were allowed to come over at any time?
No, because I used to go over there like to see my daughter. I leave to go home by 8 before she go put in bed. And all of a sudden, then she got mad at me, and then she blocked me, and I was just talking to her, and I just went over there, and I should have went over there.
Mhm.
That's when the custody thing came up in after the fact.
So what family members do you have in San Antonio?
I moved out here just for my daughter.
To co-parents
So co-parent.
from Alabama.
Well, we were trying to get together. I bought a house here and we're not together, so I'm stuck in San Antonio. So I said, and I only got here about my daughter here. I said, I'm not having no family.
So how do you all discuss childcare issues? What is happening with that? Is it through the app?
Right now, we've been talking to each other on the phone, and my daughter got a watch, and I've been hanging out with her when she allowed me to see her. Taking me, supposed to be going to see the light show tonight. So that's what I've been contacting.
With the complainant and the daughter.
Right.
So they're amicable.
Both of us.
Well, here's the thing. People hang out with each other and then they think things are great. And then maybe they'll decide that they're going to get back together. You shouldn't do that because whatever issues y'all had previously, these same issues are there.
Judge, he also has a daughter that's 17 that is in the state championship as a wrestler in Alabama. She's already not committed, but she's been offered a full ride to the Naval Academy. So we'd ask that he be able to travel freely between Alabama and I guess Annapolis, Maryland. Should that be where she commits?
All right. So what I can tell parties, I don't know why people get in relationships and then they have this issue with the children where people are not letting people see each other, not letting people see their children. But this is what I can tell you. When a relationship is over, it's over. Don't try to get back in that relationship. You and the complainant are supposed to be adults and everybody's supposed to be putting their children first.
Yes, ma'am.
And when people hurt the mother of their child, the father of their child, just being petty, then you're hurting the child. Do you understand?
Yes, ma'am. I understand.
And I can tell you, until things were explained to me, I was close to giving you jail time as a condition. But now I'm able to see everything and the state was not asking for jail time as a condition.
Judge, again, context, complaining witness and my client went to the same school, Troy University, Alabama. And he played football for the school and she was an athletic trainer, correct?
Yeah, I've been on a lot.
So it's an on and off relationship for 20 some odd years. Is that right? 6 years.
It's been a while.
Then the baby came along and tried to do the right thing, moved to Texas to co-parent, and things happen.
All righty. This is what the court is going to do. Court is going to sentence you to 2 years deferred adjudication. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days. There's to be no employment as a home health care provider or with minors. The coaching that you do, are you paid for that?
No, ma'am.
Okay, so,
I'm gonna get paid for it.
all right, so there's to be no there's to be no employment as a home health care provider with minors. There's to be 100 hours community service restitution. Ms. Abrams, if you verify that he's actually coaching, that can count towards his community service hours. Field visits one time per month for 3 months. And the complainant is requesting the no harmful or injurious contact.
Yes, Judge, and the idea is for the child custody and transferring.
All right,
There-
there's, yes.
He has total and permanent disability with the NFL, and so he's not allowed to work for that.
He'll need to provide proof of that.
Okay.
All right, so proof of employment within 40 days or proof of inability to work. And the court will require an anger management class. And I'll require a parenting class. Probation, is there anything else?
One court with no harm for injuries contact.
Oh, I'm sorry, I wrote it in, but I didn't say it. No harm for injurious contact with the complainant. All right. Is there anything else that you need from the court to be successful? All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? All right. Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right. If you complete everything early, the court will consider early termination.
And Judge, I may have not on it, but did you allow travel?
Ms. Abrams,
Yes.
he's allowed to travel to
Alabama?
events with his other daughter. So he's allowed to travel to out of state. Because maybe they're gonna go to another wrestling tournament other than Alabama.
And is that just particular to his daughter, Your Honor, or can it be
Yes.
also, he has an elderly mother because that lives in Alabama, he helps care for, he's the only child that can care for her.
All right, you all will just need to approach on that. Your attorneys will need to turn that over to probation.
Oh, thank you.
Okay.
Okay. Thank you.
Four. All right, Vashawn, just go ahead and say he's allowed to travel out of state for his child and also for his mother. And there's to be UA upon return. So that'll be a UA within 24 hours. So if you leave and you come back, it'll be the UA the next business day. And you can either do UAs or either you can do the patch. The patch costs more, but with the patch, probation will just put a patch on you. You don't take it off, don't tamper with it, because that'll be a violation of your probation. They will pull it off and then they'll test it. All right, did you review the trial court did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, because this plea bargain agreement, because I followed your plea bargain agreement and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we're off the records. They're saying they have a victim impact. Basically, what ends up happening is the complainant speaks to you. I require that everyone is respectful to each other, and usually the complainant will tell you their feelings on this offense. Do you understand?
Yes, ma'am.
Great, thank you. So if you'll stand over there and the complainant will remain seated.
Oh, okay.
Yes. Hi, Hunter.
Morning, Judge. Good to see y'all.
You too. All right, who else is ready?
Sorry, Judge, I'm working on court proceedings. Bear with me.
Okay.
Ready.
Jonathan Carter's case shows how custody battles can turn people into their worst selves. He's coaching high school football, giving back to his community, but he made a choice that could have destroyed someone. Judge Boyd gave him deferred adjudication, but not before making him confront why he did it. Next up, a GPS ankle monitor versus childbirth.
I will give you just a minute. Can you call Nicholas Rivera, please? Thank you. First, ready when I first look at them.
And what page are they on?
Page 19, first one.
Nicholas Vaquera.
Judge, can you please me out in the room with Alma Benavides and her client?
He's not on the Zoom yet.
Let me try.
We'll call him.
All right, just one moment. I'm pulling this up on Odyssey. All right, the court is calling 2025 CR 009909 State versus Nicholas Vaquera. Could I have parties announced for the record for the state?
Rick Pena for the state of Texas.
Defense?
Austin Hagee for Mr. Vaquera.
All right, and do you have the motion with you?
Do you want here?
And are you Mr. Vaquera?
Yes, ma'am.
All right, the defense has filed a motion to remove GPS bond conditions. State, do you object?
Yes, we do object, Your Honor.
All right, you may proceed. Why does it need to be removed?
Your Honor, my client is currently expecting a child. His wife is 9 months pregnant. She's here, and I do intend to call her. She can provide some information on the support that she will need. In the alternative of completely removing GPS, we would ask for tracking only. If she does end up delivering the child in the middle of the night or water break, something like that.
Do you have an objection to tracking?
I do object to the track, and I thought we had an agreement last time real quick that his current conditions can be amended so that he can attend any doctor's appointments that may still be remaining for his wife's pregnancy, as well as obviously go to the hospital with her on the day that he is to deliver.
The problem with that becomes GPS does their job well, and they can't know when something is maybe going to happen. Childbirth cannot be planned, unfortunately.
Oh, no, if there's a violation of a bond condition for GPS, it comes to me, they send me an email.
No, I understand, Judge, but you're normally not going to be checking that at 12 o'clock at night or on the weekend.
No,
And
it
if you-
comes to me and then I make a decision on whether or not to sign it. They don't like send it to somebody else because I'm not there.
Yeah.
And what I can tell you, Mr. Vaquero, with regards to GPS, what ends up happening is when they file a GPS and they say there's a violation, the first thing that they do is they call you and they let you know, hey, where are you? We have a alert that you're not where you're supposed to be. So if, for example, and I'm not saying I'm going to deny counsel's motion, but if you were at the hospital and GPS doesn't show that you're supposed to be at the hospital, the GPS tracking is going to show that you're at the hospital. And then if you're at the hospital, normally they won't call because they'll see you're at the hospital. But if for some reason they feel like you should not be there, they will call you and you can say, my wife is giving birth. This is where I am. All right, but you can continue. Do you have witnesses?
I do have one witness, and I think the concern, Judge, becomes if the monitor starts to go off in the hospital. I don't know if the staff, such as the nurse and doctor, are going to feel comfortable with him having a GPS monitor ringing while they're trying to deliver the child, and will they let him stay in the room or not? And I can just see that becoming a traumatic event for his wife and him. And I don't think that's really necessary at this particular juncture of the case, considering he hasn't had any violations in well over a year. But I will call her to come stand. America Willis.
So it doesn't have a support system to career.
Take a step back, Chief.
Step back. Thank you. Pull the back ball.
All right, can you raise your hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand, state your name for the record.
America Willis,
All right, and how old are you, Miss Willis?
23.
All right, you may proceed.
Ms. Willis, are you currently expecting a child?
Yes.
Who's the father of that child?
Netflix for Kara.
And are y'all married?
Yes.
Okay. And when did you, well, we're going to get into that. Currently, where do you reside?
This is my mother.
Okay. And do you live with Mr. Becerra?
I can tell you all right now, nobody can hear anything that's being said.
Sorry.
I can't hear. The court reporter is struggling to hear. I don't know. Today, everybody seems to be whispering.
Yeah. So if you can please speak up so everybody can hear you, and we'll add the microphone, that might help. Where do you currently live?
I live with my mother.
Okay. And does Mr. Becerra live at that residence?
No.
Okay. Is that because there's not enough space at that residence for both of you?
Yes.
Okay. And also he has a bond condition of where he can and can't stay and when he can come and go. Are you aware that Mr. Becerra has a GPS bond condition?
Yes.
And you understand he has a monitor on
Yes.
and it limits his movement? Okay. Right now, how many months pregnant are you?
9.
Do you have any other support system that can take you to the hospital?
Currently, no.
Do you have anybody else that can help you pick up formula?
No.
If you need help taking care of the child after the child is born, will you have anybody else that can be there to help you with that?
No.
And so Nick is really your sole provider for any sort of aftercare that you need after having the birth of the child.
Yes.
As hard as to say, you do understand that some people do have traumatic births and that sometimes it has a recovery time.
Yes.
And it is possible that could happen here.
Mhm.
Okay. So are you asking the court that he either have tracking only or have this device removed so that he can help you during this time?
Yes.
Okay. Have you experienced him coming to a doctor appointment or trying to come to something and his monitor go off and start beeping or having issues with it? Okay. And does he normally get his appointments approved by the GPS officer usually? Or is that sometimes hit or miss?
It depends.
Okay.
We've had one appointment
Okay, one doctor's appointment
that he's gone to.
that he's been able to go to because he has to get it approved in advance. Okay. But if he doesn't get it approved or they don't respond to him, can he just go?
No.
So everything has to be approved in advance.
Yes.
And in your experience, are these GPS officers overworked?
Yes.
Objective relevance, Your Honor, on that one.
All right, that'll be overruled. You can answer.
Okay. Does it seem that they sometimes have a hard time responding?
Yes.
And they sometimes say, only email me, do not call me, or things of that nature. They have certain preferences.
From what I've heard, yes.
Okay. And so are you asking the court that you be able to have father of your child, my client, Mr. Becerra, at the birth and able to help you afterwards by getting tracking only or having the GPS device removed?
Yes.
And you understand, and I'm sure he understands as well, that if there is a violation, they can put him back on full house arrest if they want,
Yes.
or remand him without bond if he violates in any way.
Yes.
Okay. And knowing that you're still asking that the court would put him on tracking only or remove the GPS device.
Yeah.
Okay. Is there anything else that you would like to add that the court can use in making this decision? Thank you so much for your time. You can give me that back, and you can please go sit down.
No.
I have questions.
Oh, I'm sorry. Yeah, of course. Yeah, go ahead.
May, Your Honor?
Yes.
You said your name was Miss Willis.
Yes.
When did you first meet Mr. Becerra?
2 years ago.
2 years ago. So that would be when you said you're 23, correct?
Yes.
So when you were 21, you met? And how soon after you met did you guys get married?
We got married. Then for the last years and probably over a year.
December. Okay, so December 2024. Okay, and when did you first realize you were pregnant? April of this year, okay. As of right now, do you have any remaining, I believe they're called prenatal appointments?
Currently, no. But we're doing Sunday.
Because I'm sorry?
I'm due on Sunday.
You're due on Sunday, okay. Sunday's your due date. So with that being said, do you have a hospital in mind that you plan to go to that day should baby come? What hospital is that?
This is
Matheson, okay. Are all those arrangements already made with that hospital for that day? Okay. And you said, or you testified earlier that Mr. Rickard doesn't live with you, correct? But who lives with you? I'm sorry?
My mother.
Okay, so in theory, your mother could help you out with the things Mr. Hagee was asking about as far as formula, diapers, et cetera, things for the baby.
He's pretty sick.
How is she sick?
She has cancer.
Oh, I'm sorry to hear that. I hope that your mother gets better. So I guess other than your mother, then it's just Mr. Rickera? Okay. In your life, no other family support system, no cousins, aunts, uncles, father? Okay. I'll pass the witness, Your Honor.
Any further questions?
So you're a caregiver for your mother?
Yes.
Okay, so she doesn't have the ability to help you.
Mhm.
And Mr. Vicara doesn't have parents in his life that could help either. Like grandparents that could come and be a caregiver for you or anything like that. They don't have the availability to do that. That's it, Your Honor. I have no
All
further
right, I
questions.
just have a few questions.
Sure, Your Honor. Go ahead.
Right. Before you started dating him, were you aware of these pending charges?
Yes, boss.
All right, thank you. All right, this is what the court is going to do. The defendant is allowed to attend all medical appointments involving his wife and his future child, and there should be no unsupervised contact with minors. All right, thank you.
So does that mean, ask me a question.
Okay, thank you. Amanda Farias. And which page is she on?
He is page 2, section 1 down.
All right, just have a.
I loved how Judge Boyd handled that. She didn't remove the GPS entirely. She found a middle ground. You can attend all medical appointments. The GPS will show you're at the hospital. Creative problem solving. Now let's talk about what happens when someone doesn't follow the rules for 10 years.
All right, the court is calling 2015 CR 3473 State versus Rose Padilla. Could I have parties announced for the record for the state? For the defense?
Robert Valdez for the defense.
And are you Miss Padilla? You need to, okay, everybody is whispering. Why is everybody whispering? You need to speak up so the court can hear.
Yes, ma'am.
All right, did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Rose Padilla who's placed on deferred adjudication for the offense of aggravated assault with a deadly weapon on September 9, 2015 for a period of 5 years and extended for a total of 5 years? Is that you?
Yes, ma'am.
All right, state.
Judge, if I could have just some. Judge, I'm sorry, can I have the record?
Sure.
Because
All right.
Work something out.
Yes.
I will go back on the ground.
Yes.
Yeah.
Yes.
It's on Mr. Rios. I put them, put
No,
myself on
I'm
it.
sorry, Rose Padilla
Oh.
first. That's okay. Yes.
We have, I think we have reached an agreement as to, we're gonna plead true to one of the,
All right. Are you all ready to come up then?
yes.
To provide you with any-
$81,000 owed, $254 paid over 10 years. That's the reality of restitution. It haunts you. Rose Padilla's case shows the long arm of the justice system, but our final case flips the script. What happens when the defendant claims she's the victim?
Promise you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you, I'm sorry, if you're not a US citizen, you will be deported, denied naturalization and re-entry. Did you understand? Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's a $1,500 fine. State recommends deferred adjudication. There's to be no contact with Oscar Castro, Yemi, Vanessa Bayo, Mondragon, Jesus Leyva, and the address of. Did you understand that to be the plea?
Yes, ma'am.
Defense is that the plea?
Yes, Your Honor.
State is that the plea?
Yes, it is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 7 years. There be 200 hours of community service restitution, the BIP course, TAP evaluation, follow our recommendations, and MRT. Is there a affirmative finding that's being requested in this case?
Per the code, this charge doesn't come with an affirmative finding, Your Honor.
All right.
It's for Title V offenses only, and burglary of habitation does not.
All
fall
right.
under
Well,
Title
I'll
V.
read the facts and we will see.
Yes, Your Honor.
All right. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then to the offenses charged in paragraph B, how do you plead? Guilty, not guilty, or no contest? State any evidence.
Yes, Your Honor. At this time, state offers into evidence. It's Exhibit 1 with all attachments.
No objection, Your Honor.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Our client's remorseful that this had happened. What's not in your, the stipulations, not to your knowledge, is that there was some abuse, possible molestation from the complainant against her child. And that led to this event.
Well, have there been charges filed for that allegation?
Not to my knowledge, Your Honor.
Any evidence presented to anybody for that?
This is the first time I'm hearing about it.
Okay, all right, you may proceed.
The client is employed, self-employed, does meal prep. There's a $1,500 fine. However, she may not have consistent income. I know this is for 7 years. I was hoping that the fine could be probated. She does do not professional home health care, like not a caregiver per se, but she does have to be around other people in a sense of making sure somebody doesn't fall over. If somebody needs something, she may help them. We're under the impression that this was not the affirmative finding of family violence. I had advised her that it likely would be imposed. And I would hope that you would follow the plea bargain agreement as written.
All right, so why were you over at that location? Because it appears from reading the stipulations that you were not invited.
Correct. Well, I was informed that he was there by him. This was ongoing abuse that I had been through with him. That he would stalk me. He, would find where I was. And that night I was with my friends, and he was telling me that he was going to come looking for me and that he was going to find me. Anyways, it led on to the next morning. He was still contacting me. He told me he was there. I was telling him to leave me alone. Long story short, we ended up getting into it, over the phone. So I went over there to where he was at. And that's how I ended up there.
I don't understand that. I don't understand why you would go to a location. Your attorney is saying you're in fear of him, but you go to the location. And then did you see the photos?
Yes, ma'am. And he's currently out. He was guilty of putting his hands on my son and myself as well. He's out right now. I think deferred. I don't know. I couldn't tell you the legalities of that, but and that wasn't his only time. After I was arrested with this, he came to my house looking for me again with a gun and put it to my head. And because there was a restraining order, he had one on me. I ended up getting arrested. And so this is, even me on house arrest, he was still messing with me. So I understand that I wasn't supposed to be there, or I went looking for it, but I think that just me being, provoked and going through what I was going through with him, I snapped, I guess.
Well, if he's on probation, shouldn't he have a no contact order as well?
Well, I believe that was all done prior to this taking place. His own separate case that he was placed on deferred was completed prior to this.
So he's completed probation.
He's not completed. He's on deferred at this time.
All right, so there should be a no contact order. Is that out of this court?
I don't believe so. No, it's in a different court.
Oh, okay. Well, I would have ordered a no contact, so maybe somebody should let probation know to reach out so there can be no contact.
Yes, right.
Do you all have children together?
No, ma'am.
All right, so there's no reason to have any contact with him.
Yes, ma'am.
Court is going to sentence you to 7 years deferred adjudication. There's a $1,500 fine that will be probated. There's to be no contact with Oscar Castro, Yemi, Vanessa. And Ms. Abrams, that's Yemmi, Vanessa, Bello, Mondragon, Mondragon, Jesus Leva, Levya. And the BIPP course, TAP evaluation out of custody, follow recommendations. 200 hours community service restitution. I'm going to order the BIPP course. Once that's completed, 100 hours be deemed satisfied. The MRT course, once that's completed, 100 hours we deem satisfied. Field visits 1 time per month for 6 months. Regular reporting by Zoom or in person. Regular random UAs, proof of employment within 45 days, no employment as a home health care provider or with minors. Probation, is there anything else? Is there anything else you need from the court?
No, ma'am.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
All right, we can go off the record. In this court, to be successful on probation, communication is key. If there's an issue where he's bothering you, you need to let probation know. And maybe you can see if their probation officer can recommend that as a part of his conditions of probation, that he has no contact with you. And then if he were, that would be a violation of his probation. My understanding, his case is not out of this court. Otherwise, he would have had a no contact order. All right, good luck to you.
Judge,
You're welcome.
just one clarification. The meal prep that she does is not significant. She does a side thing of helping others where it's not in a.
Maybe she's just
legal
doing
thing.
meal prep and dropping it off.
She may assist somebody with in the house movements, not make sure they don't fall over. She is not a nurse. She's not licensed. She's not a home health care provider in a sense.
If she's doing that for people, I'm assuming she has regular people that she does that for. Am I correct?
Yes.
You will have to get a letter from that person or their family stating that they're aware that you're on probation for this and they have no concerns with your providing that service.
Okay.
All right, thank you.
Thank you, Judge.
All right, we're on recess.
Amanda Farias broke into her ex's home after years of alleged abuse. Judge Boyd gave her deferred adjudication, but also made sure she'd be protected from her abuser moving forward. These cases aren't black and white. They're messy, human, and complicated. So here's my question for you. Should past trauma be a mitigating factor in sentencing? Can someone be both a victim and a defendant? Drop your thoughts below. And if you made it this far, hit subscribe. We've got more courtroom deep dives coming. See you next time.